Good afternoon, ladies and gentlemen. My name is Eric Barlow. I'm the Vice Chairman of the CSG West State and Federal Relations Committee. It's a pleasure to have you joining us today. Today, our topic is state consultation, working to make the process better. I'm pleased to represent Chairman Cindy Evans, whom I don't know is on the call yet, but we'll ask her some comments in just a moment. Rich Lindsay, our CSG West staff, is also with us and will be taking care of some of the responsibilities on this call. Ladies and gentlemen, this is a follow-up to the session we had in Tacoma at CSG West. Both of our guests today spoke there and assured us there were ongoing efforts and that we may be interested in an update. And so here we are to get an update and certainly to reach out to you and others to encourage more folks to get involved. This will also be part of the discussions in Las Vegas at the CSG National Conference, and we hope you will join the discussion at that time too. I want to offer a special thanks to Erica Miller, CSG West, for helping organize, and Lisa McKinney from CSG National for taking care of all the technical aspects of this webinar. So with that, ladies and gentlemen, I think we'll get started. As I said, Mr. Rich Lindsay will take over introductions and some of this stuff. So Rich, if you would like to begin, that would be helpful. Thank you.
Thank you, Representative Barlow. Our first panelist today, very fortunate to have Jim Ogsbury, who is the Executive Director of the Western Governors Association. The Western Governors Association represents 19 Western states, 3 Pacific territories. Jim was hired in 2012 with a charge to revitalize the organization and has since restructured the organization and has instituted reforms to better identify and promote the governor's bipartisan policy and priorities. He has over 20 years of experience in creating and implementing bipartisan public policy. Prior to coming to the WGA, he served as the legislative director for the League of Arizona Cities and Towns, managing principal of the Washington office of Tri-Advocates, an Arizona-based public affairs firm, and of counsel to the law firm of Jones Walker. He's a graduate of Harvard College and Arizona State University College of Law. With that, Jim, please take over.
Thanks very much, Rich, and thank you, Representative Barlow. I'm going to kind of fly through these first few slides because they'll be somewhat repetitive of our conversation in Tacoma, and I want to get to the main event, which is our efforts with respect to consultation. But I think it's important to establish a little bit of context. The Western governors have adopted policy resolutions on all manner of challenges in the West, all kinds of resource issues. We have policy on water management, water quality and energy, public lands management, forestry and wildfires, workforce development, endangered and invasive species, the list goes on and on. But the common theme in underpinning all of these policies and the principle that coheres all of these governors across the political spectrum is that of state authority. So next slide, Lisa. All governors recognize that states have competencies and knowledge and expertise and resources that should be brought to bear in the development and the execution of federal policy, and especially with respect to those policies that affect states and implicate state authority. And the genius of American democracy, of course, lies not only in the separation of powers among the branches of government, the executive, the legislative, and judicial, but also the division of power among the national government and the state governments, or federalism. And under the American version of federalism, the powers of the national government are narrow and defined and enumerated, while those of the states are vast and indefinite. And the 10th Amendment, of course, reads in its entirety, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. That's one sentence, it's 28 words. And yet over the years, the balance of power has shifted dramatically toward the federal government and away from the states. And the explosive growth in the size and the scope and the cost of the federal government attests to this new reality. And that growth, along with increasingly prescriptive regulations, infringe on state authority, tie the hands of states and local governments, dampens innovation, and impairs on-the-ground problem solving. Next slide. So of all the policy efforts that the governors are pursuing, I'm not sure that there are any that are as important or have the potential to affect lasting change than our work, our collective work with CSG and others, to fundamentally realign the state-federal relationship. So last December, they adopted this resolution, 2017-01, Strengthening the State-Federal Relationship. That articulates the governor's vision of a more functional relationship between the states and the federal government and presents a roadmap of how to realize that vision. And there are lots of elements. I commend it to your attention. Among other things, the policy calls for recognition that in the absence of a constitutional delegation of power to the federal government, state authority should be deemed sovereign. States should be given the maximum deference and flexibility to design and execute federally delegated programs to meet minimum standards established by statute. The governors think it's time for a fresh look at the executive order on federalism and demand much greater agency attention to state authority. Also, it's time to consider a government-wide platform for the consideration of federalism issues and the design of federal policy. That's the role that was once executed by the now dissolved Advisory Committee on Intergovernmental Relations. Next slide. But really, predicate to any meaningful change is education, and education of people in positions of great authority in the federal government who do not understand or appreciate the role of states in creating the federal government and in national governance. Stated simply, there is an astounding lack of constitutional literacy in Congress and the executive branch. And the phrase that I would love to expunge from the federal vernacular is that of, quote, states, tribes, counties, and other stakeholders. That phrase, or some version of it, recurs time and again in federal legislation, in rules, guidances, handbooks, regulations, and the like. It comes up with respect to consultation requirements or agency directives to cooperate, collaborate, or otherwise engage with external parties. And I think because of its repetition, the idea has taken root that states are to be regarded just like any other group that is external to the federal government. States are not like any other group, especially because they created the federal government and retained unto themselves the greater measure of authority. So the governor's vision is that state and federal officials work side by side, shoulder to shoulder, arm in arm, elbow to elbow, to develop and execute federal policies impacting the states from the very earliest stages at which a policy is ideated. And not just because the states have the authority, but because it's going to that process will result in better policy. Now, states and governors have on-the-ground knowledge and experience with their environments and their economies and cultures and political and legal regimes that should be taken into account at the outset of policy development. And not only will meaningful state engagement result in better policy, it should result in more legally defensible policy. If governors and federal officials are working together and jointly produce policy, then it's going to be more bulletproof, especially to the extent that such a process is going to reduce the need for states to resort to litigation, which is really the only channel available to ordinary stakeholders after the adoption of a federal rule. Next slide, Lisa. So governors recognize that the relationship between state government authority and federal authority is complex and it's multidimensional. And there are various contexts in which the authorities of these respective levels of the U.S. government manifest and intersect. So this matrix identifies some of those different flavors of the state-federal relationship. So, for example, those areas where the feds have exclusive authority, as in national defense and immigration, and where states have exclusive authority, as in the case of groundwater management, or where states have delegated authority to administer programs that are mandated by federal statutes. So most of the Clean Air Act and Clean Water Act programs, and those cases where states and the feds share authority. And I think any serious effort to improve the state-federal relationship has to recognize these different incarnations of the state-federal relationship and address the issues specific to those different contexts. Next slide. So with that as background, WGA has been conducting a multi-pronged campaign to promote the governor's vision of a better state-federal relationship. So using that resolution on strengthening the state-federal relationship as a basis, we recast that as shared principles of federalism, which were adopted by several groups. The initial adopters are really a core group that we've been working with are all Western policy organizations representing state and local officials. And of course, that includes CSG West and the Conference of Western Attorneys General, the Pacific Northwest Economic Region, and the Western Interstate Region of the National Association of Counties. So we've taken those principles, we've sent them to the entire membership of the House and the Senate. We've distributed them to officials throughout the executive branch. We've met with key committees of Congress and congressional leadership. On the administrative side, we've met with the White House and CEQ, Office of Management and Budget, select federal departments like Agriculture and Interior. And then in response to the White House call for regulatory reform plans by agencies, WGA developed a matrix of recommended reforms, largely calling for the adoption of those shared federalism principles. So we've been sharing this matrix with new political leadership of agencies as they've appeared on the scene. We've also been added to the Speaker's Task Force on Intergovernmental Affairs. We held federalism policies and federalism policy summits in Washington, D.C. last winter and in Denver this past August, largely to expand the tent and get more groups associated with this effort. And then we, with CSG and others, created what we are calling the Western Policy Network. And that is an informal confederation of Western policy associations with common interests that are organized for the purpose of information exchange, issue identification, and calls to action in areas where we might be able to leverage our collective influence or resources. And the emerging portfolio of this new group is broader than the state-federal relationship, but its creation was a product of that effort and it really remains a unifying theme in which all of the members are interested. So right now we've got 17 organizations represented, that core group that I identified earlier, other associations of state officials like the Western Interstate Energy Board, the Western States Water Council, the state foresters, the Western States Lands Commissioners. We also have some national groups involved, including ECOS, the Environmental Council of the States, and the National Governors Association. Next slide. So the master key to improving the state-federal relationship is meaning consultation by the feds with states. And here is the governor's policy on consultation. And I'm just going to, because it's so important, so central to this conversation, I'm just going to take a second to read it. Each executive department and agency should be required to have a clear and accountable process to provide each state through its governor with early, meaningful, and substantive Western Governors Association input in the development of regulatory policies that have federalism implications. This includes the development, prioritization, and implementation of federal environmental statutes, policies, rules, programs, reviews, budgets, and strategic planning. So the consultation process should really involve a measure of accountability, enforceability, and substantive effect. And in terms of substantive effect, consultation should be prosecuted in a way that distinguishes the interests of the states from those of the general public. State consultation should be designed as its own process with a clear set of procedures. What we know consultation is it's not notice and comment. In those cases, at least in those cases where statutes direct agencies to consult with states, the courts have ruled that Congress must have intended something more meaningful and substantive than just Administrative Procedure Act notice and comment procedures that are available to all external parties. So that process should involve an effective and transparent system for identifying when proposed actions or decisions require consultation with states. That should involve a record of any decision not to consult with states. And federal agencies should engage in early pre-rulemaking consultation with governors or their designees during the development of rules or decisions and prior to the occurrence of any decision-making process. States should also be provided the opportunity to review any proposal before formal rulemaking is launched. And governors and designated state officials should have the opportunity to engage with agencies on an ongoing basis to seek refinements to proposed federal regulatory actions prior to their finalization. And consultation processes really have to involve a two-way substantive dialogue in which governors or their designees have an opportunity to present information, including opportunities to discuss the details of any proposal, the potential impacts of those proposals on state authority, and possible alternatives to any proposal. With respect to accountability, federal agencies should designate a specific agency official to coordinate state consultation requirements and be accountable for their implementation. Consultation procedure should include a requirement for the federal agency to analyze the effectiveness of any requirements once they've been implemented. And then with respect to enforceability, federal agencies should be held responsible, probably by OIRA, the Office of Information and Regulatory Affairs, for developing and abiding by a strong consultation process with states. And a mechanism should be available for states to appeal when a federal agency fails to follow its consultation procedures. I just want to take a minute to mention tribal consultation, and offer a couple of program notes, because that got a great deal of attention in the Obama administration. And early in his term, President Obama issued a memo to agencies regarding the implementation of a Clinton-era Executive Order 13175, consultation and coordination with Indian tribal governments. And that EO recognizes that the federal relationship to tribes is a government-to-government relationship. And this Obama memorandum required the development by agencies of implementation plans to implement that EO. It requires that any proposed rules be accompanied by a tribal summary impact statement. It imposes annual reporting requirements on agencies. It urges the identification of agency officials responsible for the tribal relationship. It resulted in creation of Office of Tribal Relations and the publication of handbooks and how-to manuals. I'm looking at the manual of the National Oceanic and Atmospheric Administration. It's got a 33-page manual on how to consult with tribes. And these aren't necessarily a model for state consultation. And I don't think they're robust enough to meet the needs of states for meaningful, substantive, ongoing, and consistent consultation. But their very existence kind of belies the notion that it's too hard to consult with 50 states when the feds have already committed to such excruciating procedures for 556 federally recognized tribes. And one notion I pulled from the USDA manual on tribal consultation that I think is relevant to states is its principle of mutual concurrence, which states, as a general principle, consultation only occurs when the office or agency and tribal officials mutually agree that consultation is taking place. So next slide. So I invite you to check out our website, www.westgov.org. We're populating a new page on that site on the state-federal relationship, where we'll have a number of resources. And as we move forward, we've got a few things in the works. We've got another discussion among interested groups in Washington, D.C. on February 27th. That is planning is underway for that right now, another federalism summit of sorts. At WGA, we're working to draft kind of a legislative primer that would include model language on consultation. And we're also working with departmental solicitors to see if they'll issue statements on the constitutional status of states, so we can kind of break through this notion that states are like other stakeholders. And next slide. And that's where I'll stop. Thanks very much.
Jim, thank you very, very much. I think what we'll do today is I will introduce the next panelist, and following Pete Obermueller's presentation, we'll open it up for questions for all the attendees. But thank you very much for that presentation. The next panelist is Pete Obermueller. Pete is the Executive Director of the Wyoming County Commissioners Association, a post he has held since 2013. His duties include representing the state's 23 counties and 93 county commissioners before the Wyoming State Legislature, working collaboratively with the Wyoming Governor's Office and other state agencies on local government issues. He's a Wyoming native. Pete's a graduate of the Hubert H. Humphrey School of Public Affairs at the University of Minnesota with a master's degree in public policy. Before this position, he was legislative director to United States Representative Cynthia Lummis from Wyoming. He also served as the executive director of the Congressional Western Caucus, a legislative group composed of members of the U.S. House of Representatives who promote Western and rural interests in Washington. I might add that probably one of the primary responsibilities or reasons why Pete is here is because he gave nearly this same kind of presentation at the CSG West State and Federal Relations Committee meeting in Tacoma just recently, and Representative Cindy Evans, the chair of that committee, said, I like that presentation so much, I think it should be a part of the webinar that's coming up in November. Pete has an interesting look at how this consultation also ends up going all the way down into local communities and counties. So with that, Pete, take it over.
Well, thanks very much, Rich, and thanks Representative Barlow and Representative Evans for the invitation to come back. Appreciate it. It is a little bit of a repeat from the time in Tacoma, though a couple of updates along the way as well about all of this. It's interesting to listen to my friend Jim Ogsbury speak, which, by the way, I tend to just steal everything Jim does because he does a great job. So I want to highlight a couple of things he said that I think are extraordinarily important. But it's sort of interesting that we do this sort of when we start talking about Fed consultation with the states, we do this kind of, well, in this case, I guess a little bit of a reverse leapfrog. We're talking about Western governors, and I'm going to be talking to you about county officials and what does that mean for state legislators? That is an interesting question, and it's my strong belief that state legislatures play a vitally important role, but it's a role that I think is sometimes a little bit, perhaps doesn't feel like enough to legislators. At least that's the message I sometimes get here in Wyoming, and interested to know how other folks view that. But from our standpoint, the partnership we have with state legislatures is very, very important. That's why I kind of have this little flippant title here, the feds, the counties, and you, because you as individual legislators and your state legislatures do play a critical role here, even though sometimes it might seem like not. So we'll go through this real quickly, and then I really love to take some questions. I know in Tacoma, some of the things that I mentioned, specifically with regard to Wyoming's federal natural resource policy account, there were questions about that we did not have time to explore. So we'll hopefully have time for that. So let's get started with the next slide. Thanks. So this is a map that's probably familiar to most of you. If you're in the West, it's obviously just the federal land distribution. It's just an interesting look, kind of a unique look of how that looks, and it's somewhat interesting, I guess, that we're having this call today and following up on this on the day of the opening of the court case in Nevada regarding Cliven Bundy and his sons and some supporters regarding their standoff in Nevada and the implications that has with respect to federal ownership of land and federal management of land and the cooperation and levels of acceptance of that in the West. It's a real issue, and it's an issue born out of real and legitimate frustrations in the West that, in my experience, our friends from the East on both sides of the aisle don't quite understand, and so it creates this problem. But interestingly, in recent months and years, over a period of time, the discussion has been this duality of whether or not it's federal ownership. That's the question, and that's a legitimate question. It's not a question for today. What I want to talk about is what do we do under the current structure, and there are tools available at the county level and at the state, obviously, and with the legislatures to move an agenda forward, even if you're part of those states in the West that have large federal lands. So next slide, please. So before I get to that, the reason why the relationship that the legislature has with counties, both in terms of moving forward on federal lands, like I mentioned just a minute ago, but also in terms of relationship with state legislators, is the role counties play with respect to federal lands that relieves some pressure on state legislators. So I just listed a couple of these here because I think these are critically important. A lot of the discussion about federal lands does have to do with economic vitality and the ability of counties and their communities to support economic growth. And for a lot of us, that comes down to revenue and how much the state can help with revenue. So you all are familiar with most of these, I'm sure. Payment in lieu of taxes, which in FY17 was about $465 million nationwide. I just listed some states there. I can tell you with absolute certainty that if PILT were to go away, the $28.6 million lost to counties in Wyoming would be an enormous burden on Representative Barlow and his colleagues at a time when our budgets in the state are suffering anyway. So with that and secure rural schools, counties really on our own fight very hard for PILT payments, really on behalf, obviously it's on behalf of ourselves, the selfish motives, of course, but without that, the pressure on states would be enormous to make up for that lost revenue to counties. One I added here I didn't talk about in Tacoma that I wanted just folks to be aware of too is, particularly if you're in an energy producing state, you're familiar with the federal revenue sharing for oil and gas and coal and hard rock mining and others that share revenue with states, particularly with that go directly to states. There are federal revenue sharing and federal revenue sharing potential with counties that we're also working on, specifically talking about wind generation. You all may be aware that wind generation has no federal revenue sharing. They don't have royalties in the sense that oil and gas does, but they do pay pretty significant lease payments for operating wind farms and turbines on federal land. But there is zero revenue sharing with the states on wind production. We believe that is the wrong approach, and we're trying to change that. And legislation currently pending in Congress would share revenue with the states and revenue directly with counties where these wind farms are operating. We support that bill, and would be interested in talking more about that. So that's sort of step number one for state and local consultation is the work counties do to attempt to relieve some pressure on the states. And it's not one we talk about much. We just work on those sort of on the outside, but it's important to us that you all know that. Next slide, please. So then beyond that, when we start talking about the tools that we have at our disposal for consultation that currently exist, a lot of this is it's a tough slog. It's difficult to talk about. It takes a little while to understand it, and it takes constant vigilance. And I'll get into that a little bit. But the two biggest tools are coordination and cooperation. They are separate, but they are related, and they have varying degrees of effectiveness, both depending on your local government's willingness to use them and to use them in a meaningful way, and as important, sometimes more important, the federal agency's willingness to abide by the requirements that both of these place on them. So we'll start with coordination and cooperation, and we'll talk about what your role is in those. Coordination is a statutory requirement. It's in both FLPMA, that governs Bureau of Land Management, and in NIFMA, which governs the national forests. Coordination requirements exist in both of those. Next slide, please. So under FLPMA, it's clear and unambiguous that they, as Jim mentioned before in his presentation, the Bureau of Land Management must coordinate with states and local governments, and that coordination is more than just comment and notice and comment. I absolutely love and I'm completely on board with Jim's campaign to remove the notion that states and counties are stakeholders. It is clear from the courts that we are more than that. And there is, I believe, a concerted effort to knock that down. Interest groups from all walks, whether it's conservation, environmental, or even on development on industry side, to level that playing field, to allow narrowly focused single issue organizations to have the same level of access and input as local government and state government. And that is fundamentally not what Congress intended under FLTMA or NIFMA. Regardless of what you might think of any particular political leanings of your local government or your state government, their obligation is to everyone in the state or the county. And that in and of itself it doesn't always in practice, but it should provide a broad policy vision when it comes to coordinating, and that is critically important. The other thing is that we'll talk to a little bit more is that it's clear that the BLM must adhere to the terms, conditions, and decisions, quote unquote, of local land use plans, as long as they do not violate federal law, and that's a critical caveat. Next slide, please. NIFMA is the same, though a little bit less stringent. It still requires to coordinate with state and local government, but the process is not quite as defined. I think most importantly, the Forest Service denies that it has to follow FLTMA's coordination mandate. They don't quite have the same wording in what that coordination looks like. In the case of the BLM, they must try to conform. I shouldn't say conform, adhere to the policies, plans, and programs of local governments, state and local governments, and if they don't, they need to explain it. The Forest Service doesn't necessarily have that same level. But as Jim pointed out, and this is quoting some court cases, coordination goes beyond simply trying to work together, but rather negotiating to work together effectively. What that really means, and this is true both of Forest Service and BLM and really any other federal agency, is negotiating to work together effectively is not a one-off event. It is a long-term, constant, and intentional effort on the side of both local government and on the federal agencies. If either one slips away from that, then it doesn't work. And that, at least in my work with Wyoming's counties, is the most difficult thing to get across, particularly if the federal agencies are being standoffish or stonewalling. That continuing to engage and be intentional about engaging does pay off in the long run. That becomes a difficult sell when the federal agencies are not holding up their end of the bargain. So we constantly have to work on that on both sides. Next slide, please. So the question might be, well, if they have to go adhere to the mandate or adhere to plans, policies, and programs, then what how is it that they can get out of it? And this is really the critical debate that divides a lot of us in the West on these tools of coordination and cooperation. There are arguments out there that all you have to do as a local government is quote unquote invoke coordination, and all of a sudden the federal government will have to bow down to whatever it is the local government would like. Unfortunately, as much as we wish that were true, coordination is not a trump card. There's been a lot of smart people working on these for a number of years since FLTMA has passed, and if we would have figured out that it were a trump card, we would have played it a long time ago. There are too many caveats, and there are too many clear laws, not the least of which the United States Constitution, that clearly gives the federal government the final say when it comes to disposition and management of federal lands. I know, as mentioned, the Bundy case earlier, and other things out of Utah, that there are concerted efforts to upend that. I'm not speaking one way or the other about the validity of those efforts. What I'm talking about right now is what our current authority is and how we can use it. So next slide, please. So it's not really a trump card, it's more like a jack. It's sort of good, but it's not great. Here's why it doesn't necessarily work as a trump. I mentioned it doesn't overrule federal regulations, and most especially the Constitution. And because of that, it doesn't require that the BLM or the Forest Service adopt any particular local plan or policy. There's a lot of leeway to the Secretary of Interior and the Secretary of Agriculture to determine whether it does violate federal law, and a lot of discretion in terms of what the federal agencies view as to a maximum extent practical. So it is, like I mentioned before, it's an ongoing process with responsibilities on both sides. And we in Wyoming, and I know a lot of my colleagues in other county organizations across the West take that process very seriously and try to up our game constantly. One thing I wanted to point out about this, and I'm going to come back to it a little later too, because it's important for you all to know, particularly when you're talking to your county representatives about how they're deploying their resources to deal with federal lands. There's a movement out there that's right now that's saying that local governments must have a natural resource policy plan in order to have the federal government coordinate with those plans. That isn't true, but let me put a fine point on it by saying this. Natural resource policy plans are meaningful and important, and if everyone could have them, it would help us all. They are broader than just comprehensive land use plans in any county that deal with any sort of land use issue. They're more specific and more geared towards natural resource. They are critically important, but they're also sometimes expensive, and they take a lot of resources and manpower and expertise that at least a lot of counties in Wyoming simply don't have the resources to do. And what's critical to know is that FLTMA and NIFMA are clear that the federal government has a coordination responsibility with local government plans, policies, and programs. Policies and programs are very important. In the now defunct BLM 2.0, initially they tried to get rid of policies and programs and require a plan. And we at the Wyoming Association fought hard against that because we believe that the federal agency should not dictate what kind of plan you have. Local governments can have whatever plan, and they're required to coordinate with it. So it's a bit of a distinction, but it's important to know that you do not have to expend those resources in order for the federal government to have a coordination obligation. Next slide, please. So moving on to cooperation. Cooperation is a stumbling block for a lot of folks, at least in my association and sometimes elsewhere, just because of its name. It indicates that it's some sort of happy Sesame Street thing about cooperation. Bonus points to anyone who remembers that particular Sesame Street skit pictured there with the geefle and the gonk. It's not like that. It doesn't necessarily mean that you agree. What it is a regulatory mechanism that allows for political subdivisions to participate in National Environmental Policy Act related activities. This is important. It's separate from coordination, but it allows local governments recognized as having specific expertise, listed socioeconomics, and to be at the table in pre-decisional discussions about major federal actions on federal lands. And this really is where the rubber meets the road on what Jim was talking about earlier about states and local governments not being stakeholders. What the various single issue interest groups would like is this exact seat at the table. Pre-decisional access, equal opportunity with local governments and states. And that is what we will push back against forever because for reasons I already stated. So it's important to know that cooperation doesn't mean that you get along. It just means that you're there. And for us in Wyoming, what we've tried to do over the past few years, and with reasonable success, is to up our game on bringing to this cooperation table meaningful and defensible data rather than just anecdotes and anger. That's what we've been trying to accomplish. Again, it's not always an easy sell. Next slide, please. So finally, with those two things in mind, the question of the role of the state legislator, of a former state legislator here who always said when it came to what they could do at the state legislature, it was the only authority they had was to write a terse letter. While that is true, there is so much more to it. The trouble is, and we've experienced this here very recently in Wyoming with respect to tribal consultation that Jim talked about before. Agencies are really loath to come talk to state legislatures, as I'm sure you've know, in part because you're a hydra, and nobody knows exactly who's in charge when you're talking to a state legislature, and that is difficult. There's not necessarily a unified message at the state legislative level, and so there's not a great mechanism for legislators to be involved in the coordination and cooperation process, except for via your state and local officials. And so there's a couple of things. One is to both empower and encourage your local officials to be on the front lines and to be effective at it. This is tough because most, at least in my experience, a great many county commissioners run for that office because they're angered at the quality of the road that leads to their house. They get elected and they're surprised when I send them a 700-page EIS and ask them to read it. In order to have that work, they have to be both empowered and encouraged to do so on behalf of the state. They really are your front lines at the end of the day. And you can, and Wyoming has done this in a number of ways, use your individual and collective authority to ensure that local governments and local government officials are doing it and are advancing a message that is in line with what you would like them to do. That's certainly within your power, and there are at least 3 committees in the Wyoming legislature that does that we report to on several times a year on all of these, either as individual counties or as association or both. Next slide, please. So an example of how they do that here in Wyoming, and I mentioned this before, is what we call here in Wyoming the Federal Natural Resource Policy Account, FNRPA. This was begun in Wyoming several years ago. A couple other states have followed suit and created this account. That's express purpose is to help build the capacity of local government to be the front lines for you. And this is the role that I think is so very important for state legislators, is that you are the ones that can really empower us to do a better job on this over time. So in Wyoming, it's a legislatively appropriated a pot of money. It's not huge. I think it's generally around $1.5 million annually at this point. It's administered by the governor, and then it's generally used by counties, but also by some special districts and all of that for a lot of things. Socioeconomic profiles, as I mentioned, to litigate when necessary, and then really mostly it's intended to help build internal capacity so that we can have defensible data and to fend off snake oil salesmen. This one is critical. There are a lot of groups out there who travel around the states. They've been in Wyoming. I'm confident they've been in many of your states, where they'll come to counties and say, hey, if you didn't know, you can invoke coordination, and the federal government will have to do what you say. All you need to do is pay us $10,000, and we'll make sure that you're doing the right things on coordination. That drives me crazy. It's unconscionable. I don't blame counties for liking that message, because doing this work is a slog, and if someone tells me that they can just take care of it, that'd be worth a lot. The trouble is it doesn't work that way. it's a constant and intentional ongoing effort, and simply paying somebody $10,000 to quote unquote invoke coordination, people will be sorely disappointed. It's money wasted, money better spent on being better prepared. But it's important to know that those groups are out there and trying to make a little bit of a buck on a cottage industry on that. So that's how FNERPA works in Wyoming, and both my association and individual counties receive a lot of grant money from that for this purpose. Next slide, please. Oh, good. Last slide. So open to questions on any of that or anything else you may have heard during the presentation. Thanks so very much, Representative Barlow and Rich, for the invitation. Sure appreciate it.
Pete, thank you very much. Thank you both. Extremely insightful presentations. Really appreciate it. Now is the time when if anybody's got questions out there, or if you've sent one in to let us know, and because we'll open it up for questions. I do have one question actually for both of you, which would be, I know when you look, and Jim, you talked about the Administrative Procedures Act, and really, you know, it just is fairly broad about what really the federal government has to do in terms of making regulations. So in an agency like, like the Department of Interior, and we all know there are a number of agencies underneath there, the process that is invented to allow people to out in the communities, the states and whatnot to have feedback, is that something that's standardized for all those agencies within the Department of Interior, or do each one of those agencies actually come up with whatever process they decide, how many days, who actually they have to contact, et cetera, et cetera? I'm just curious about that.
Yeah, so this is Jim, and I'll jump in and go first, and just to say that is, you know, in our examination of consultation issues, that's certainly one of the things that we've identified as a real problem, is a lack of uniformity, different across agencies and within departments. There tends to be hugely disparate treatments of states and consultation procedures, and we found that you'll see the same thing with the Indian tribal consultation mechanisms vary wildly among agencies and within departments.
Pete?
Yeah, Jim's right. It's interesting. I mean, it should be more uniform than it is. I guess, the two parts to your question. For most folks, the notice and comment period is their only opportunity. In general, it's hard to say, but in general, that should be pretty uniform. With respect to, early and meaningful consultation, that really varies, and it varies. Not only does it vary between agencies, it varies between field offices, as I'm sure many of you know. And we have found just by necessity that we often play the role of not only reminding federal agencies of their obligation, but also linking one agency with another so that they'll talk to each other along the way too. And that's a role we don't think we expected, but it's one that's ended up being a necessity to make sure that we try to unify as much as we can.
We have a question from Representative Barlow. What responses are you getting from the White House / the executive branch ? To these efforts? Is a new EO possible? Is a new executive order possible?
So this is Jim. So the president did issue an executive order on regulatory reform, and I talked about that a little bit in the presentation. And we have been, very aggressively promoting those recommendations throughout the administration. And I think it's going to be kind of a matter of a couple months before those it becomes really clear what those regulatory reform look like agency by agency. But our our initial read is pretty positive. We know that folks in the administration are taking it seriously and having a hard look at it. When we met with the Department of Agriculture, for example, they were very familiar with what the governors had been promoting and indicated a good deal of agreement with many of those recommendations. So I would say that at this point we're cautiously optimistic. It's been problematic that so many positions in the bureaucracy remain unfilled. We've got a number of packages ready to go as soon as somebody arrives to look at it. But in the meantime, we're proceeding apace and talking to really whoever we can.
Thank you, Jim.
Yeah, real quickly, Rich, on the county side, everything that Jim said is right. On a broader scale, on the county side, because of the Congressional Review Act that ended BLM Planning 2.0, that, of course, just put us back into the planning process at the agencies that we had previously, which we were not fans of anyway. That needs improvement. So we've been working at the local level on potential changes to the planning process over time. I don't know that it will end up with an EO, at least not a presidential EO. We may end up with a secretarial order on that and changes in planning. The issue for us is just trying to make sure it's a difficult conversation because it's easy to give them a list of things we want, but what we run up against is giving them basically just a check the box list that once they do that, even if it's not meaningful, they say, well, we've met your list and walk away. So that's the challenge we're having on that.
Thank you. Lisa has informed me that there are no other questions. If there are no other questions, I will pass the baton off to Representative Barlow.
Well, thank you very much, both to Jim and to Pete for their insightful comments and continuing this dialogue within the CSG community. Thank you to Rich, Lisa, Erica for your work on getting this put together. We look forward to seeing you in further discussions on this issue and hopefully some of you at CSG National when this topic comes up. On behalf of our chairman and myself, thank you and have a super day.